Good morning. This is your Kelso Report for Wednesday, August 29th, and I'm your host, Clark Kelso. We begin today with a First Amendment case. The defendant in United States v. Perelman had fraudulently obtained a Purple Heart and wore it in public. The government indicted him for violating Title 18 U.S.C. Section 704A, which prohibits, among other things, the unauthorized wearing of military medals. The defendant pleaded guilty but reserved his right to appeal the district court's rejection of his First Amendment facial challenge. The Ninth Circuit held that the statute survived the defendant's facial overbreath challenge insofar as he was charged with knowingly wearing a fraudulently obtained medal. At the end of its just concluded term, you may recall that the United States Supreme Court held in United States v. Alvarez that Section 704B, which criminalizes false statements about the receipt of military decorations or medals, was unconstitutional. Well, the Ninth Circuit distinguished Alvarez, noting that Section 704B was a content-based suppression of pure speech, and that's presumed invalid. By contrast, Section 704A criminalizes not pure speech, but instead the harmful conduct of wearing a medal without authorization and with intent to deceive. The use of a physical object goes beyond mere speech, according to the Ninth Circuit, and suggests that the wearer has proof of the lie or government endorsement of it. According to the Ninth Circuit panel, the government has a compelling interest in preventing fraudulent wearing of military decorations, and the incidental impact on speech is insufficient to render the statute unconstitutional. Interesting analysis by the Ninth Circuit. Next, we have a case involving contempt. The business in FTC versus e-debit pay had settled a suit brought against it by the Federal Trade Commission, alleging that their online marketing of prepaid debit cards and short-term loans to consumers in the subprime market violated Section 5 of the Federal Trade Commission Act. As part of the settlement, the business stipulated to a final order prohibiting it, among other things, from, quote, misrepresenting, expressly or by implication, any fact material to a consumer's decision to apply for or purchase any product or service, including, but not limited to, close quote, a list of specific products and services. The business then marketed two new products that arguably were not on the list of products mentioned in the stipulated order. The first, a shopping club membership program, and the second, a no-cost debit card. The advertising associated with these products was misleading. The FTC applied for an order to show cause why the business should not be held in contempt for violating the final order through their marketing of those two products. The district court found the defendant in contempt and awarded the FTC the full amount of loss by consumers, a whopping $3.8 million. The Ninth Circuit affirmed. The business tried to argue that its two new products were not part of the list and that the general language preceding the list needed to be given a limited reading consistent with the products in the list, according to the venerable principle of ejusdem generis. While acknowledging this venerable principle of interpretation, pursuant to which general words are construed to embrace only things similar in nature to those enumerated by specific words which follow, the Ninth Circuit nevertheless held that the principle applies only when the language is ambiguous. In this case, the broad statement that the defendant was enjoined from making misrepresentations with respect to any product was not ambiguous, and it was language the defendant had agreed to. Accordingly, the Ninth Circuit agreed that the defendant was in contempt, and it affirmed both the finding of contempt and the contempt sanction. Not a good day for the defendant. Next, we have an interesting Second Amendment decision from the California Court of Appeal. The defendant in People v. Mitchell was found guilty of violating former Penal Code Section 12020, subdivision A4, which prohibits the carrying of a concealed dirk or dagger. On appeal, he asserted that this statute violates his constitutional right to bear arms for self-defense. The 4th District rejected this argument. Now, a dirk or dagger is defined by the statute as a knife or other instrument with or without a handguard that is capable of ready use as a stabbing weapon that may inflict great bodily injury or death. The statute does not prohibit carrying a visible dirk or dagger. It only prohibits carrying a concealed dirk or dagger. And that was the key feature for the 4th District's analysis. Applying intermediate scrutiny to the statute, the court concluded that the ban served the important governmental interest of allowing third parties to protect themselves from exposure to the risk of a surprise attack from a bearer of a concealed weapon, and that the ban was reasonably tailored to serve that interest, since the risk of a surprise attack exists even if the weapon bearer originally intended to use the weapon only for legitimate self-defense. Accordingly, the ban on carrying concealed dirks or daggers was constitutional under the Second Amendment. The court did note in its analysis that just historically, there have always been restrictions on carrying concealed weapons, which suggested and that the Supreme Court had recognized in general the validity of those types of regulations upon firearms. Finally, we have a Commerce Clause case involving revenue and taxation. California's Revenue and Tax Code provisions allow an individual California taxpayer to defer capital gains on the sale of stock in a qualified small business if the taxpayer used the gain to purchase stock in another qualified small business. The deferral was available, however, only if the stock sold and purchased was issued by corporations that used 80% of their assets in the conduct of business in California and that maintained 80% of their payrolls in California. Well, in Cutler v. Franchise Tax Board, the 2nd District struck down these provisions under the Commerce Clause because they discriminate on their face against out-of-state commerce by affording taxpayers a deferral for income received from the sale of stock in corporations maintaining assets and payroll in California, while no deferral is afforded for income from the sale of stock in corporations that maintain assets and payroll elsewhere. As the court explained, the deferral statute favors domestic corporations. Here, corporations with 80% of their assets and payroll in California over their foreign competitors in raising capital among California residents, and tends to discourage domestic corporations from plying their trades in interstate commerce. And that's it for today's Kelso Report. Have a great day in the law.